Good afternoon, everyone, and thank you for joining the ADR practice section with a very exciting presentation by Judge Perez. My name is Ann Dalton, and we put on these little CLEs once a month, or try to do it once a month. And we're here today. Judge Perez is going to acquaint us with the ins and outs of the Unified Family Court. Judge Perez has been a circuit court judge assigned to the Unified Family Court since October of 2020. Prior to that time, he was a family law magistrate, commencing in May 2015. He's been a Supreme Court certified family law mediator since 2015 as well. He became board certified in family and marital law in 2011 and continues with that status. Prior to that, he was in private practice for 10 years. He is a former prosecutor, including an assignment in juvenile division. And he's also represented the Department of Children and Families in Dependency Court. So he has a fantastic background for the 20th Judicial Circuit. And we're also recording this, and it will be on YouTube later. So if you have friends or others who wish to watch it later because they can't make it today, it will be available on the Lee Bar Association YouTube website. So with those comments, if you have questions, I'm going to ask you to please put them in the chat. Lauren and I will be monitoring the chat, and Judge Perez has graciously left some time for us to be able to ask your questions of him. I will communicate your questions to him so he will not be interrupted in his presentation. Thank you, Judge Perez, for giving us this time today.
Thank you, Ann, and good afternoon, everyone. It's so nice to see such familiar faces, even if we're socially distant and via Zoom. My hope today, my goal is to demystify Unified Family Court for some of you. My plan is to talk about, like the title said, the who, what, why, and how of Unified Family Court. So I'm going to start with the easy part, the who. Here in Lee County, the who of Unified Family Court, in terms of the judges, is myself and Judge Swift. Of course, we have a great team. We have our wonderful JAs. We have a case manager assigned to Unified Family Court, Cindy Valenti. We have our deputies, our clerks. We have a great team. In Collier County, the Unified Family Court judge is Judge Shannon McPhee. In Charlotte County, it's Judge Mary Evans with an assist from Judge Bell that does delinquency. In Hendry County, we have one circuit judge, Judge Sloan. So he does it all, but Judge Hill does do the delinquency and some of the domestic violence. And in Glades County, Judge Lundy has a special circuit assignment and does all the unified cases. But basically, what do we hear in Unified Family Court? A lot of cases. First of all, we have our family law matters. And of course, that includes Chapter 61, dissolution of marriage cases, Chapter 742, paternity, and Chapter 751, temporary custody. We hear domestic violence cases. And as some of you that practice in that realm, you know that when we say domestic violence and domestic violence injunctions, we're not talking anymore just about domestic violence. There's injunctions against repeat violence, dating violence, sexual violence, stalking, and there's some other ones. I could go on, but I won't. We also hear risk protection orders. For those of you that may not know risk protection orders, those are governed by Florida Statute 790.401. In those cases, a law enforcement officer petitions the court for an order alleging that a respondent poses a significant danger of causing personal injury to himself or others by having a firearm or any ammunition in his or her custody or control, or by purchasing, possessing, or receiving a firearm or any ammunition. And that statute came around. It's also known as the Marjorie Stoneman Douglas High School Act. But here in Unified Family Court, we hear risk protection orders. We also hear dependency cases, and those are the cases governed by Chapter 39. And the dependency case is one in which children are abused, abandoned, neglected, or at risk of abuse, abandonment, or neglect, and are dependent on the state for protection. Parents are offered a case plan and an opportunity to be reunified. Also in dependency court, we hear termination of parental rights cases. In Unified Family Court, we do the delinquency cases, and those are the juvenile delinquency cases where the state is bringing a petition alleging that a child has committed a delinquent act. We hear sins fins cases, and I'll try not to use acronyms too much, but sins fins basically is child in need of services or family in need of services. Those are governed by Chapter 984, and those are cases in which the children are safe with the parents, but the family just needs some help to address certain issues. And I would say that 99% of those cases are cases where children are not going to school and are just refusing to attend school. So they're basically truancy cases. And finally, we hear judicial waiver cases, and those are governed by Florida Statute 390.01114 subsection 6. And those are cases in which a minor has petitioned a court to allow the minor to waive parental consent to terminate a pregnancy. So as you can see, there's quite a bit of areas of law, a lot of different statutes, a lot of different rules of procedure. And I'm going to get into a lot of those differences a little bit more. But that's the basic what of what is Unified Family Court. Now, why do we have Unified Family Court? And I've been working in the family law areas since I graduated law school, basically. And as early as 2000, Justice Pariente at the time started an initiative. She believed it was very important that a family only have one judge. In all these cases, there's a potential for a family to come before a judge. And many times, a lot of these issues are all going on at the same time. We have parents that are going through a divorce. All of a sudden, the divorce or allegations of abuse, and the case now becomes a dependency case. Parents seeking an injunction. Child's a teenager. The child picks up charges because of the stress at home from the divorce. The child decides he or she's going to act out. So we now have a delinquency case. To take it to the very extreme case, the child acts out by taking his father's gun and threatening to shoot up the school. So now we have a risk protection order issue. So you can see where a lot of these issues can overlap. And historically, each of these separate cases would come before a different judge. So we had one judge ruling on the divorce issues until dependency got involved, and then one judge ruling on the dependency issues, but then a delinquency judge hearing the child's juvenile delinquency case, another judge hearing the restraining order case. So what could possibly happen with that scenario, with all these different judges hearing all these different matters for the family? What do you think is a possibility? And I recognize a lot of you, so I'm not afraid to pick on any of you. So if anyone wants to unmute themselves and think what the possible consequence could be of all these different judges dealing with a family. All right, I'll pick on Vera. Ms. Bergerman, do you have a mic?
Yes.
What do you think is a possible consequence of different judges hearing all these different issues?
Right hand doesn't know what the left hand is doing.
Right. And as a result, what can happen is conflicting orders.
That's correct.
You could get an order in DV that says one thing, an order in dependency that says another, a delinquency judge enters an order that provides for something else. And all these, that was one of the main reasons the Supreme Court felt it was important that if there's one family, there's one judge. We want to avoid the left hand not knowing what the right hand is doing, and we want to avoid the duplication of orders. We also, if it's one judge hearing all these cases, that judge has a lot of knowledge regarding what's going on with respect to some of these other issues, which may play into what should or should not be done. And another reason is we want a lot of these courts that we preside over are service oriented. For example, dependency and juvenile delinquency, and you want to avoid the duplication of services. to the different families. We always talk about services, and we want to make sure that we utilize our community resources in the most effective way. So those are just some of the reasons why we've gone to a unified family court system, and why the Supreme Court now requires it, and every circuit has unified family court. So I wanted to talk a little bit about demystifying it. I said I promised you I'd try to take the mystery out of it. So how does a case get to unified family court? And there's two different ways. One of them is original jurisdiction. And I'm not talking about personal or subject matter. I'm just talking about the fact that there are certain cases that immediately upon filing go into the unified family court judge. And those cases are the delinquency cases, the child in need of services or family in need of services cases, the dependency cases, and the judicial waiver cases. So if one of those cases is filed here in Lee County, it immediately gets assigned to either Judge Swift or myself. The other way that cases get to unified family court is by a transfer by the administrative judge. And that's probably where you all, at least the family law practitioners, where most of you come in and don't understand exactly why your case is in front of who it is. So those cases are family law cases, the domestic violence cases, and the risk protection orders. Those are the ones that are transferred by administrative judge. So what happens in those cases are someone files a petition for dissolution of marriage, someone files a petition for injunction, or law enforcement files a risk protection order. And then a case manager reviews the file, and they note, well, they're originally assigned to a family court judge, because those three types of cases are typically assigned to the DR division to family court. Case manager reviews the case, and if in the last 24 months, one of the parties has had either an open dependency or delinquency case, or a child subject to the proceeding has been the subject of a dependency or delinquency case, then that case gets transferred to a UFC judge. So even if you come in and the dependency case has been closed for a year and a half, it can be closed for a year and 364 days. But if you file it on that day, right before the 2 years, it's going to get transferred to unified family court. Similarly with petitions for injunction, and if you have an active divorce case where it's been even if it's been going on and you're set for trial for a final hearing on your petition, if a dependency case is opened or if a delinquency case is subsequently opened, that case is going to be transferred to the unified family court judge. So one thing that often happens is if there is a divorce pending and all of a sudden we have a dependency case, under Florida law, the divorce pretty much comes to a standstill, because the statutes say that first you have to address the dependency issues before you come back into family court. So those are the cases that create the most interesting issues, are those transfer cases. Does anyone have any questions about the whole transfer and how a case comes to UFC from family court or DV court or domestic violence court?
There are no questions in the chat, Judge. Thank you.
Great. I just know that that's the one that, when I was in practice was pre-UFC, so it didn't come up, but as a magistrate, I get a lot of questions from attorneys that didn't understand. And honestly, in the beginning, I didn't understand either until I sat down with our court administration and our case manager to kind of learn the process. So I know that can be tricky, but that's how a case gets to UFC. So let's talk a little bit about the differences, and I'm going to stick to family cases, dependency cases, and delinquency, because those are the majority of the cases that we hear. So I'm going to talk a little bit about what the differences are between those types of cases. Let's start off with the parties, okay? In delinquency court cases, it's easy. The parties are the state of Florida and the child. Those are the parties in a delinquency case. In a family law matter, usually the parties, and usually the parties are the mother, the father, maybe a guardian ad litem. And again, I'm not talking about the 751 temporary custody by a relative, but your standard divorce or paternity case. Now, in dependency, who are the parties? Well, obviously the mother, the father, usually the Department of Children and Families. There are some cases where a private party brings a dependency action, but usually it's the Department of Children and Families. The child is a party in dependency cases, and the guardian ad litem. So right there, we have a big difference between family and dependency, in that the child is actually considered a party. And in dependency, we're also more likely to have guardian ad litems than we do in family court. There's the statewide office of guardian ad litem, and in each circuit, there's a guardian ad litem office, and we have state guardian ad litems, or what's called a child advocate manager, that works within the guardian ad litem office. And then there are a number of volunteer guardian ad litems that volunteer their time to serve as a guardian ad litem for the child in dependency court. So you're more likely to see a guardian ad litem than you are in family court. So the parties are different. Another big difference is the right to counsel. Now I'm going to focus a little bit more on family and dependency, because this is an ADR practice session meeting, and mediation is more likely to come up in the family and dependency arena than some of the other areas I deal with. So let's talk about right to counsel. Is there a right to counsel in family court? I see Ms. Rogers nodding no. That is correct. No right to counsel in family court. In dependency court, there is a right to counsel. There's a right to counsel at every stage of a dependency proceeding. That starts from the very first stage, which is typically a shelter hearing. A shelter hearing is when the Department of Children and Families is called to investigate allegations. They believe the child has either been abused, abandoned, or neglected, or is at imminent risk, and they believe the child needs to be removed from the parents. Well, under Florida law, you're required to have a probable cause hearing within 24 hours of that removal of the child. At that very first hearing, at that shelter hearing, the parents are entitled to counsel, and we do appoint counsel for them. The reason for this is that the Supreme Court, the US Supreme Court, has determined that you have a fundamental right to parenting your child. Therefore, in dependency court, where you're more likely to, where the state is seeking to interfere with your rights to parent your child, the law has determined that parents are entitled to an attorney. Now, does that mean that parents are entitled to an attorney at their dependency mediation? What do you think? And I know, Anne, you do dependency mediations, don't you?
I do, and I believe that answer is no.
No, tell me why. What do you think about that?
I believe there's a little quirk in the law that doesn't provide for an attorney during mediation, or the party can decide they choose to go unrepresented for that mediation. It's my understanding.
All right. So, and Anne is right. There is that distinction. So, I mean, I would be more likely to set aside a mediation agreement if the parent in a, for example, a termination of parental rights case didn't have an attorney than if they did. But there is a quirk in that area. And I raised the issue for that reason, because I know there's some discussion both ways. And then, any questions about the right to counsel? To give you just a little bit background of how counsel are appointed in our cases, the first thing we do is, obviously, you're always entitled to bring your own attorney. And even in dependency cases, you are entitled to represent yourself. But if someone comes in front of me and they tell me in a dependency case they want to represent themselves, I have a pretty lengthy inquiry with them regarding why they're choosing to do so. And I ask them if they understand that if they qualify, an attorney can be appointed for them. But they fill out an indigency application with the clerk. The clerk makes a determination whether they qualify or not. And then we look to the Office of Regional Conflict Counsel. In our 5 district, we have the state of Florida separated into 5 districts. Each district has a regional conflict counsel. In our area, the head of that office is Ida Nemotin, and she has attorneys that represent parents in independency court. So we look first to the Office of Regional Conflict Counsel to see whether they can appoint one of the parents. And if they cannot represent one of the parents, or if we have 2 parents, or in some cases we have 3 parents because there are multiple children and one mother with multiple fathers, then we have a wheel of attorneys where you sign up for this wheel with the clerk's office, and you need to qualify. You have to have the requisite experience, and then the clerk will put you on this wheel where you indicate you're willing to accept appointment for this dependency case, and you are paid for it by the JAC office. You are paid for each dependency case that you are appointed on. But if anything, you are interested in joining that wheel, you can contact the clerk's office for more information. But that's where the court-appointed attorneys come from. They come either from the Office of Regional Conflict Counsel or from the wheel that the clerk's office has. So let's talk about another difference, interpreters. Is there a right to an interpreter in a family case where the court has to appoint and pay for an interpreter for you? What do you think? All of you that practice family law, you know the answer to that question. What do you think, Alan? Does a husband or wife get a court-appointed interpreter? You're muted, so I see you speaking, but I can't hear you.
I was muted, I'm sorry. In a divorce case, I believe the answer is you're not entitled to an interpreter.
And that is correct. The person is responsible for obtaining and retaining their own interpreter in a family law case. Now, there is one exception. If you look at the Florida Rules of Judicial Administration, if it is a paternity case and the paternity is in question, for example, the father is asserting his paternity rights and the mother is saying, no, he is not the father, because of the interest in the fundamental interest there in parentage, for that aspect of the case, the father may get an interpreter appointed by the court. But once that issue is decided, which is usually decided pretty quickly with a DNA test, for the rest of the case, the parenting issues, the child support issues, because there is not that fundamental interest at stake, you do not get a court-appointed attorney. And again, I'm not making those calls. That's based on what the Florida Rules of Judicial Administration say regarding who gets an interpreter and who doesn't. Now, in dependency court, the parents do get a court-appointed attorney because we need to make sure that they are understanding everything that's going on. And I can tell you that since becoming a judge in Unified Family Court, I've learned about all these languages I didn't realize even existed. There's all these different dialects, and in some cases I've had 3 interpreters, 1 Spanish, 1 Quechua, 1 Cachabal. So there's all these dialects and languages that I honestly was not aware of. I was pretty aware of Spanish and pretty aware of Creole and those interpreters, but in dependency court, the parents are entitled to an interpreter and they are court appointed. How about at mediation? Are the parents entitled to have an interpreter at mediation?
No, and I wish. Too many people bring in family members, and that's always a problem.
So they don't get a court-appointed attorney for mediation? They have to bring a family member?
If an interpreter, that's correct. That's correct.
And why does that create a problem when it's a family member?
Well, because a family member normally has a stake in the outcome, or maybe is alienated from the other parent, or maybe isn't that parent's child and wants to see a particular outcome, especially with custody. It's just horrible.
Right, right. And I'll tell you, I know I have the benefit that I'm fluent in English and in Spanish. And I can tell you, interpreting is not easy. It is not an easy job. I certainly wouldn't want to do it. It's a challenge. And we have some great certified court interpreters, but you can see the difference from when a friend or family member tries to interpret versus a Supreme Court certified or court certified interpreter. And a lot gets missed. A lot gets missed in the translation. I can tell you that. So that's why interpreters are so important, and why they're so important in dependency court. All right, let me move on to another major difference, and that is the attendance of the child. So we'll start off with family court. We all know Rule 12.407, testimony and attendance of a minor child. Children are prohibited from attending court without a prior court order, and that court order must be based on good cause. In dependency, Rule 0.8255 subsection B, it's the reverse. A child has the right to be present for every hearing. Now, a court can conduct a hearing in the child's absence if the court finds it's in the best interest to do so. That rule is also very broad. It's a lot broader than the 12.407 rule. 8.255 gives the court discretion to start the hearing with the child present and then excuse the child when we get into subject matters that maybe the children shouldn't be listening to. For example, the allegations of abuse or new allegations, or maybe some other issue regarding the parent's compliance with a case plan. So the court does have discretion to excuse the child. That rule specifically enumerates special protections for children who do testify, which 12.407 does not. For example, in-camera testimony. I can tell you that I've done now 2 termination of parental rights trials where the children did come in and testify, and they testified remotely. So if any of you have been to our dependency courtroom in 3A, that courtroom was designed specifically with the assistance of Judge Seals to be a dependency courtroom. So there is a room specifically designed for children. And there's a bookshelf with children's books, there are toys, there's a small children's table, there's a couch. It's a child-friendly room. So in those trials, what I did is the child was testifying in that room. So the child did not have to see the mother or the father or anyone else. I came into that room to ask questions of the child that have been prepared by the attorneys and have been stipulated to by the attorneys. Now, I told the child exactly what was going on, that who was in the other room and who could see him or her, but the child was testifying in another room as opposed to being in the same courtroom with the parents and everyone else. So that is probably one of the biggest differences, besides the child being a party, is the child's attendance in court. Any questions about children in court? And I know last month or the month before, the family law section actually did a whole presentation on child testimony. So I didn't want to spend too much time on it, but just know that that is a big, big difference between family and dependency. And when it comes to Rule 12.407, remember that rule also applies in domestic violence court. Every injunction, every order that's signed on an injunction generally is stamped with a message that says you must seek prior court approval before you bring a child to court. So the family law rules also apply in domestic violence court. So the next difference rules of evidence. Are there different rules of evidence in family court as versus dependency court? What are your thoughts? What do you think, Ms. Rogers? Same rules of evidence apply? I can't unmute you because I was taken away from
trying to get my unmute up. I have no idea. I don't know the answer to that. I would guess not, but I don't know.
Well, you know, and a lot of people make the assumption that there are different rules of evidence, but it's actually the same rules of evidence. We have the same rules of evidence and dependency as in family court. Now, there are a couple exceptions, and the one that sticks out strong is a shelter hearing. A shelter hearing, like I mentioned earlier, it's that first hearing within 24 hours immediately after a child has been removed. And that's probably most similar to what we call a first appearance or a bond hearing in criminal court, which also has to occur within 24 hours of an arrest. And a shelter hearing, the standard for removal is I have to find probable cause, which is a pretty low burden. And the statute specifically states that for purposes of probable cause at a shelter hearing, I can rely on hearsay. That is the only place that the statute says that I can rely on hearsay, and it's similar to criminal court at a first appearance. So at a shelter hearing, I can have a witness come in and testify and say, the child told me that the father hit him with a belt across the face. I can rely on that hearsay at a shelter hearing. I cannot rely on that hearsay in domestic violence court when mother comes in and says, my son told me that dad hit him across the face with a belt. Just like when I'm sitting in family court hearing the custody of the parenting issues, I cannot consider that hearsay either. But at the shelter hearing, you can. And I apologize. Let me tell you, I've had to when I started practicing family law, the terms were custody and visitation. I then had to retrain myself when I resumed practice of family law to time sharing parental responsibility. Well, now guess what? Now I'm in dependency court where we're back to custody and visitation. And then I leave courtroom 3A where I'm talking about custody and visitation. I go to 6A where I'm doing a divorce case and talking about parental responsibility and time sharing. So I do my best not to interchange the terms, but it does happen from time to time. So yes, we do have the same rules of evidence. What we don't have is the same rules of procedure. And as you all know, the rules of procedure are broken up into different chapters or different rules. For example, the mediation rules are 10, right? And mediation rules all start 10 point something or other, okay? The family law rules are all 12, 12.200, so on and so forth. We just talked about 12.407. The dependency rules and the delinquency rules and the children in need of services and family need and services rules are all under chapter 8 or rule 8. So the delinquency rules and the dependency rules are all under rule 8. Rule 8, however, is divided into a number of separate sections. So one section deals with strictly delinquency. One section deals with dependency. We then have different rules for termination of parental rights. And then we have different rules for children in need of services or family in need of services. So we do deal with different rules of procedure. And that's critical because for the attorneys that practice in both areas, the rules are significantly different. And one rule that doesn't apply in either family or dependency are the rules of civil procedure. Not too long ago, the family law sections were changed so that they're all encompassing. In other words, we no longer, if you're in a family matter under 61 or 742, only the rules of family procedure apply. Similarly, if you're in dependency court in a dependency matter, only the dependency rules apply. So if you're asking for relief under a civil rule, you better make sure that there's a family law rule if you're in family court or in dependency court, a dependency rule. So although we have the same rules of evidence, we do have different rules of procedure. Any questions on that?
There's no questions in the chat. Thank you.
That's great. We're moving right through this. We're going to be done in no time. And we can all have lunch. I want to talk a little bit about burdens of proof. For most family law cases, what is the burden of proof? Let's see, someone having called on. Ms. Zachary, you have your video off. Are you still there?
I am. Good afternoon, Judge.
Good afternoon. What's the general burden of proof in family law? Is it proof beyond
competent substantial evidence?
Right, and is it proof beyond a reasonable doubt? Do you need
No, Your Honor.
All right, that is correct. So you need competent substantial evidence, and for the most part, it's just a preponderance of the evidence, just that 51% of competent substantial evidence to get you over that hurdle. Now, there are some examples, for example, a contested 751 custody, the statute specifically says that when it's a relative against a parent, you must have proof by clear and convincing evidence. But for the most part, it's preponderance of the evidence. Now, in dependency, we have different types of cases, different burdens of proof. I already talked a little bit about a shelter hearing, and at a shelter hearing, you only need probable cause. Now, after a child has been removed from the parents and the court has entered an order finding probable cause, the next step is the department decides whether or not they'll be filing a petition to adjudicate the child dependent. And adjudicating the child dependent means that the child is dependent on the state for services, that this family needs services in order to ensure that the child can be safely in the home. And sometimes the department files a petition keeping the child in the home. Sometimes a petition is filed with the child out of the home. When the petition is filed, the parents must be served with a petition, and then they have what's called an arraignment. It's a little different than the criminal arraignment. You're not pleading either guilty or not guilty. At the arraignment for a dependency case, you're either admitting the allegations, you're denying the allegations and asking for a trial, or you're consenting to the adjudication. And what it means when you consent is that you're neither admitting or denying the allegations, but you're consenting to the department's services and to the adjudication. If a parent enters a denial and asks for a trial, like the trial I'm in right now, today is a dependency trial where the parents denied the allegations. In that instance, the burden of proof is a preponderance of the evidence. I have to find by a preponderance of the evidence that the department has proven its allegations. If the court grants the petition, the case is set for what's called a disposition hearing. At the disposition hearing, the parents are offered a case plan, and a case plan is basically a list of different tasks that the parents need to do to get their children back and to get the department out of their life. So at this disposition hearing, parents are offered a case plan. They're told they need to comply with these tasks. They're told what those tasks are. If the parents do not comply with the tasks within a certain amount of time, and generally it's 12 months after the child's been removed from their home, the state can choose to file a petition for termination of parental rights. Or if the cases come in and the allegations are so serious that the department believes the parent should not be offered a case plan or an opportunity to be reunified, the state can immediately file a petition to terminate parental rights. Once we get to that stage, the parent is served with a petition for termination of parental rights. And after service, they have what's called an advisory hearing. It's no longer called an arraignment. I don't know why. That wasn't my decision. That was the legislature many years ago. Maybe because at this hearing, I'm required to advise them of a number of their rights, but it's called an advisory hearing. And at that point, most cases, the parents are going to enter a denial and they're going to ask for a trial. When I'm having a trial on a termination of parental rights petition, the burden of proof is clear and convincing evidence. So it's a higher burden, and that was decided by the US Supreme Court years ago, that in order to terminate someone's parental rights, you must find that by clear and convincing evidence. There is an exception, and I hate to put it out there, but we're in Southwest Florida and we have several registered tribes within our jurisdiction. If the child is a member of a Native American tribe, let's say a Seminole or Miccosukee here in this area, there's something called the Indian Child Welfare Act that automatically elevates those burdens of proof. So for a dependency case, the burden of proof becomes clear and convincing. And for termination of parental rights, the burden of proof becomes proof beyond a reasonable doubt. So independency, burdens of proof are different than in family court. And even within dependency itself, we have different burdens of proof depending on what stage of the case we're at. Any questions about that? Because that was a lot.
No questions, but Judge, honest, if I may ask you a question, it's a little off topic. Can you talk a little bit why the standard of proof is different for Native Americans? I think I know that answer, but I'd be curious on your perspective.
My understanding is that the legislature determined that it was the interest in making sure that Native American children stayed in Native American households. And that's why the burden of proof, the tribe can actually elect to become a party and participate in a dependency proceeding when the child's when the parent's a member of the tribe. And I believe, again, I haven't studied that in ages, Anne, but that's my understanding, that it has to do with that the federal Congress at some point determined that there was a strong interest in making sure that the children could stay within their tribe.
And that's my understanding as well. And I've been reading a lot about the Canadian First Nation situation. And it's just an interesting acknowledgement of what's happened in the past. Thank you.
You're welcome. Right. Another difference is the jurisdiction. And again, in family court, you can make parenting decisions until the child turns 18. And again, you can address child support until the child turns 18. And again, I know there are some exceptions. In dependency court, it's generally until a child turns 18. But if there's a child in foster care at the age of 18, that child can decide to stay in what we call extended foster care. And the court can retain jurisdiction over that child so long as the child stays in extended foster care. The difference is that once the child turns 18, the parents are no longer parties. They no longer have a say. They're no longer involved in the case. Now it's just the department, the child, the guardian ad litem. There's also a limited exception where the court can maintain jurisdiction over a child until the age of 22 if the court has previously made a finding of special immigrant status and the child's is a dependent, abused, abandoned, or neglected child that's trying to obtain legal status in this country. The court can retain jurisdiction until the child's at the age of 22. But again, that's a very limited exception. So those are the two differences regarding jurisdiction. Again, in family court, we're generally done at 18. Dependency court, most of the time, but usually the children choose to stay in foster care because of the benefits. There's a place to live. They're assisted with education, with college. They have services available to them if they need continued therapy. There are a number of reasons why a child might choose to stay in extended foster care. They can still benefit from some of the college and some of the other educational resources, even if they're not in foster care. But a lot of kids stay in foster care for that reason. And we're still required, when there's a dependent child, the court's required to review the case at least every 6 months. And likewise, after a child reaches the age of 18, we're required to review the case at least every 6 months. There's some exceptions. For example, we have to have a hearing within a certain amount of time of the child's 18th birthday, and that's to make sure all issues are addressed before the child ages out. So for the most part, it's every 6 months. So those are the basic differences between the family and dependency. And again, I didn't want to talk about some of the other areas like domestic violence, the risk protection orders, and delinquency, because mediators don't generally work in those areas or don't have those cases for purposes of mediation. But that's a good segue into now mediation in unified family court. So in family matters, you all know what you can mediate and what you cannot, right? That's pretty straightforward. You can pretty much mediate everything: equitable distribution, parenting, child support, alimony, attorney's fees. Am I missing anything? I think that covers, but you can pretty much mediate everything. But how about dependency? You know, in dependency court, there are a lot more parties. There are different issues. What are some of the things that are amenable to mediation in dependency court? Well, I'll start, in the first stage of the case where a child's been removed. The department's filed a petition for adjudication in dependency. Now, because of limited resources, historically, mediation happened in almost every dependency case. Again, Anne may have some more history on this. Shortly after I became a circuit court judge, we were advised that mediation would only occur in a dependency case after all the parties had certified that in good faith they tried to resolve the matter without a formal mediation, and they were unable to do so. But you still see a number of dependency cases at mediation, don't you, Ann? Because I know a couple times, I see them still not as often as before. And basically what's happened is we've encouraged the parties to do what they probably should have been doing, and is talk about their case before mediation. So what can you mediate in a dependency case? Well, one thing are the allegations in the petition. Maybe there's just some wording or language in that petition that a parent just finds so difficult to consent to that with the help of a mediator, the department and the parent can come with some different language that maybe is more agreeable to the parent. And a lot of times I'll see mediation agreements where it includes a statement that the department agrees to amend its petition to say the following. So I know that's one of the things that's happening at mediation. Another is you can mediate the placement of the child. Maybe the child's in foster care and the parent is adamant that they want the child placed with a family member or with a close family friend. And mediation is a good place to discuss this. Now, there's still going to be some requirements. There has to be what's called a home study done on that placement. There has to be a home study includes background check, fingerprints. Sometimes the person may have what's called a disqualifying criminal history. There's a list of criminal offenses in the statute that makes a person disqualified from being an approved placement. So placement of the child can be discussed and is often discussed at mediation. The other one, though, that I think is probably where a mediator proves to be the most helpful is in assisting the department and the parents and the guardian ad litem to agree as to what tasks the parents need to do in order to be reunified with their child. So those are some of the areas. And again, I will fully disclose, I'm a family law mediator, not a dependency mediator. So I'm going to ask Anne to chime in. And what am I missing? What can you all mediate since I didn't take that training, what else can you mediate a dependency case?
A final visit between the parent who's giving up their parental rights and the child.
That's right. And I was getting to termination of parental rights, but at the dependency stage, let's say that we're still at that stage where their goal is reunification. Can you think of anything else I missed other than allegations, placement, and case plan tasks?
Visitation issues. A lot of times what will happen is there's conflict between the foster parent and the biological parent. And that sometimes leads to the biological parent not having the contact with the child. And
excellent.
That's a good place to resolve those.
Excellent. And I saw Ms. Garant turn on, and she does a lot of dependency work. Ms. Garant, anything else that you can think of is a good subject for, and again, we're at the dependency stage, not termination stage. What else can you maybe resolve with the help of a mediator?
I like to always discuss benchmarks to progress the parents forward in their case to unsupervised visits, unsupervised overnight visits, and possibly an in-home case, so that instead of just an open-ended whenever the case manager feels like progressing, that we have specific tasks and occurrences of events that could serve as a benchmark to pace the case and keep it moving forward.
Excellent, excellent example. And I'll be a little more explicit for people that maybe haven't done a lot of dependency. For example, there might be an agreement that after 3 negative urinalysis for controlled substances or 3 clean drug screens, the parents will be progressed to unsupervised visits. Or maybe or an agreement that after the parents attend half of their parenting classes, the parents may go to unsupervised visits. So that's what Ms. Garant means by specific benchmarks, so that the parents know what they need to accomplish and the department knows what the benchmarks are. Thank you, that's a great example. Then there's also mediation and termination of parental rights cases. And that's where one of the things Anne referred to was last visits. You know, is there going to be a final visit between the parents and the children before the rights are terminated? And the statute does provide some language, but also that's something that could be negotiated. Sometimes at that stage, the parents also can, once again, raise the issue of placement. Maybe they're willing to surrender their parental rights if their mother, sister, cousin, friend is the one that's going to have custody and possibly adopt the child. And you would think that that happens early on, but believe it or not, sometimes cases get to this point, and that's still a point of negotiation. And again, there's still a lot of requirements. The ultimate say is on the department. There has to be home studies, background checks, and these home studies are a lot more extensive than the placement home study. Another area that's a good area to discuss at mediation is there going to be post-termination contact? For example, I've seen agreements that our mediators are very helpful with in determining whether or not there are going to be letters sent to the biological parents with updates or with pictures or what's going to happen in the future. So any other things that any of you can think of besides that? Ms. Daniels just typed in the chat, not only with parents, but also between siblings. That's another good point, another issue to be decided in mediation. What kind of sibling visitation might happen in the future? Any other issues for you dependency mediators?
There's also the possibility of holding the petition in abeyance or granting the parents an extension of time to become reunified. As some of you might know, the court can either terminate rights or adjudicate the child dependent again and give them more time to complete their tasks. So that's another thing we often try to do in termination mediation.
That is correct. That's another one. Thank you, Ms. Garant. Anything else we're missing, Ian?
I can't really think of anything else. Thank you.
All right, so that is basically it. That is unified family court in an hour or so. Believe me, there's so many different areas and so many nuances in these statutes and rules of procedure, so many differences that, believe me, it does take some, I could probably talk for hours and hours about each one, but I wanted to keep it to that hour. So that is all I have, and I'm welcome to, I'd love to answer any questions that you all might have.
Well, I think one thing that to pick up on what Teresa said, and I know Teresa's not shy, so if I get it wrong, she'll you'll correct me, it's not only siblings or half siblings, but it's siblings who are involved in different dependency matters sometimes. And whether one of the children has found to be, I'm going to use the wrong word, Judge, found to have created an at-fault situation. And if you're crossing dependency cases in an attempt to get sibling time together, that can be a very, very complicated situation.
Absolutely, because if the siblings are placed in different homes, or there different caregivers involved, so there are a number of other factors.
Or if there's allegations of violence that haven't been proven yet.
Right, absolutely, absolutely. That can be a tricky situation, and I think mediation would be very helpful for the parties in that scenario as well.
Well, thank you very much, Judge. This has been a wonderfully informative presentation. I had a lot of questions, and you did a really great job in answering them. So, and I know you spent a lot of time on your outline, so we're very, very, very grateful. Thank you.
Thank you.
And at this time, we'll be concluding the presentation. If anyone has a presentation they'd like to hear about or actually present, please get in touch with me. I'm really easy to find. So thank you very much, Judge, and we're concluding at this time. Thank you.
Thank you, everyone.